Let me welcome you to XReg's first webinar on the proposed markets in crypto assets regulation, or MiCA, on what is expected to be a momentous week for crypto assets. So let's start talking about MiCA. As I'm sure all of you or most of you are aware, the proposed text of MiCA was leaked in the press approximately 2 weeks ago. The leaked draft appeared to be a very advanced version of what we expect to be published shortly. So MiCA will introduce a very comprehensive and extensive legislative regime for crypto asset issuers and service providers. It will no doubt have a significant impact on the crypto world. Once the proposed regulations are published, the EU legislative process will commence. And this will present all of us an opportunity to consider its implications and raise any issues, call for any changes before it becomes directly applicable legislation. In this presentation, we will be introducing MiCA and what is in scope. We will be taking you through some of the key requirements for issuers and service providers. And we'll also be highlighting some of the implications for consideration. We'll also be talking about what are the next steps and what are the things that people need to start thinking about. So let me thank you all for attending this webinar, especially at such short notice. We really appreciate you taking the time to join us. I'd also like to thank INATBA, of which we are a very proud member, for providing us with the facilities and logistics for this webinar. Some of you may have seen a high-level 2-page summary of MiCA, which we published a week ago, explaining how it might affect issuers and service providers. Over the next week or so, we will be publishing a more detailed explainer paper. And if you want to receive an advanced copy of that paper, we will be showing some details in a later slide of where you can subscribe to get this information. This will be one of the first of what we hope to be a series of webinars on this subject. So I'll give you a little bit of background about XReg and who we are. XReg is a specialist regulatory consultancy firm, currently with a 7-strong and growing team of former regulators and policymakers, all with practical experience in the development of regulatory compliance strategies relating to crypto assets. Our clients include governments, regulators, public bodies, and crypto firms, private crypto firms rather. We provide policy and strategic advice to the public and private sector across the world. We assist governments and national authorities on the design, development, and implementation of legal and regulatory regimes. And we also offer training and education on crypto assets and DLT, helping upskilling teams, as well as helping them build capacity to regulate and supervise this sector. We also carry out gap analysis for crypto asset businesses, helping them understand and meet any regulatory obligations. Let me now introduce the team. So Siân Jones is a senior partner at XReg Consulting. I'm sure many of you know Siân. As XReg's strategy and policy lead, she has extensive experience in policy formulation, regulatory framework development, and implementation that is leveraged by governments and public authorities to guide the development and policies within their jurisdictions. Siân is a member of the ISO Technical Committee on DLT. She also sits on the Financial Markets Law Committee, Scoping Forum, and DLT Working Group. And until July 2019, was a technical expert on virtual assets on the FATF's Policy Development Group. Siân gave evidence on virtual currencies to the European Parliament in 2015 and has participated in many discussions on crypto assets in Brussels since then. Before XReg, Siân worked at the Gibraltar Financial Services Commission as a senior advisor on DLT, having previously architected Gibraltar's DLT regulatory framework. Anna is our policy and international affairs manager and one of our leads on this new piece of regulation. Before joining XReg, Anna spent just under 4 years at the Gibraltar Financial Services Commission, where she was part of the authorizations team and later the international affairs team. I'm also a partner at XReg. I'm a qualified lawyer with 9 years experience in financial services regulation. After that, I headed the policy team at the Gibraltar Financial Services Commission, where I led on a major reform program of all financial services legislation in Gibraltar, which included the transposition of numerous EU directives and the implementation of EU regulations. I also worked very closely with Siân and the team on the development of the legislation and the framework around DLT providers in Gibraltar. So without further ado, I'll hand over to Siân. So Siân, the floor is yours.
Wake up and smell the coffee was a slide I presented a little over a year ago at the V20 conference, shortly after the FATF published its interpretive note and guidance on the inclusion of virtual assets and virtual asset service providers into its regulatory framework. This was a seminal moment, and today I think we're facing yet another seminal moment, because anytime today, we believe, certainly we've been told to expect publication today. It might be later in the week, we don't know. It may well be during the course of this very webinar that the European Commission publishes its new EU crypto asset law. This is going to be called the Markets in Crypto Assets Regulation. Anyone who knows anything about EU legislation will immediately have picked up on the term regulation, because this makes it instantly, once it comes into force, instantly applicable across all member states of the European Union. And because of the nature of this particular piece of legislation, also the three additional European Economic Area jurisdictions, Norway, Iceland and Liechtenstein. Now, the European Commission's been working on crypto for many years. Ernest mentioned, I gave evidence on what was then seen just as virtual currencies over 5 years ago in Brussels, and it's certainly the case that the European Commission and legislators have been keeping an eye on crypto for several years before that. Up till recently, up till last year, and the new commission, the new 5-year commission that came in around about September time, not an awful lot happened with crypto in the EU. But the Commission and the other institutions decided that it was time to respond to demands for a clear legal framework. These were demands not only from regulators and legislators, policymakers and others, but also from the industry. And so they sought, in providing a clear legal framework, to also support innovation, consumer and investor protection, and market integrity, and also financial stability. The extent to which they've found a balance in the proposed legislation will remain to be seen, but you can expect that this legislation, once it comes into force, will have a lifetime of at least 5 to 10 years. Now, I should say that our comments today are by way of a briefing, and it's a briefing based on the authoritative leak that was made of the draft, this 168-page paper by a trusted news source in Brussels, Politico. The final version, when it's published today or whenever, will undoubtedly contain some minor changes, but I don't think we can expect an awful lot to be different. And as it proceeds through the legislative process, we can expect further amendments. And I'll talk about the timeline in a later slide. One thing is certain, and this is clearly set out in the intention that the Commission had when it indulged in several consultations earlier this year, including one public consultation, and when it published a non-paper, as it's called, a policy paper principally addressed at member state governments, sounding out the ideas that it had and some of the options. And through the summer, it's refined those ideas, and now we see what is an almost finished piece of legislation. It's very clear that this is going to regulate all crypto assets and all related activities. And we'll be talking about what are crypto assets, what are the different kinds of crypto assets that it defines, and also which kind of activities are brought in to the scope of this regulation. But essentially, when we highlighted the word all on this slide, we meant all. There really doesn't seem to be much scope for anything to fall between the cracks. For starters, the regulation aims to set some rules for token issuers. And as you'll see shortly, token issuers cover pretty much the issuers of all kinds of crypto assets. And it also defines what needs to be included in white papers. It turns some types of stablecoin into e-money. And e-money is something that's been regulated for some time, so it immediately sucks in those regulations and legislation that already exists. It imposes a set of very strict rules on what are referred to as asset reference tokens, and we'll explain what we mean by asset reference tokens as we go through this presentation. And it also brings significant stablecoins, that's the word that's used, significant stablecoins under government control. It establishes essentially an EU-wide authorization and supervision regime for crypto asset service providers. So if you're familiar with traditional markets legislation around the markets in financial instruments, you may know it by its acronym MiFID, then you can look at roughly parallel types of activities and see how all those parallel crypto-related activities, or at least most of them, seem to be drawn into this new regulation. And this regulation is not just going to be additional to any of implemented legislation for crypto assets or some aspects of crypto assets. It is very much the case that when this regulation comes into force, everything else in this particular space, national legislation in other words, melts away. It disappears and it's replaced by this new regulation. Without a doubt, certainly in my mind, this is going to have a profound impact on crypto assets and everyone who's providing crypto asset services. So let's look what we mean by affecting all crypto assets. Well, a slightly précise definition, but essentially the definition that's proposed in the draft is a digital representation of value or rights which may be transferred and stored electronically using distributed ledger or similar technology. It's a very broad definition, and it pretty much brings into scope every kind of token and coin that certainly I've seen over the last 10, 11 years in this particular space. And when we say it's going to affect everyone in crypto, it basically means those who issue crypto assets, or at least if they want to offer them into the European Union or have them traded in the EU. Indeed, anyone offering crypto assets in the EEA, and also this new category of financial intermediary, we'll use that term loosely, known as a crypto asset service provider, or CASP. And in bringing in CASPs, it will also regulate crypto markets, not only the operators of crypto markets, but also market conduct, market abuse, the use of the misuse of information, and so forth. But having said it covers everything, let's look at this perhaps from the bottom of this pyramid working upwards. We say that it really covers all crypto assets, that which I've just defined, or which is defined in the regulation, but which I cited in the previous slide. all crypto assets, including utility tokens, are considered to be crypto assets. There's then a layer on top which says, but if you're a stable coin, and I'll come to what the definitions are of stable coins in a moment. If you're a stable coin, you're going to have to consider some additional rules. And in determining those rules, you really have to put your stable coin, I guess, into one of two or potentially three categories. If it's a stable coin that is referenced by a single fiat currency, then it's going to be an e-money token. And it'll be subject to specific rules as an e-money token. If it's referenced to any other kind of asset, that could be a basket of fiat currencies, it could be other cryptocurrencies, it could be other assets altogether, physical or other assets, then it will be deemed to be an asset reference token, and it will sit with some separate rules of its own. And as you can imagine, as we work our way up this pyramid, we will find ever stricter rules and regulations. So from the base set of regulations that we have applying to all crypto assets, we work up through stable coins, and eventually at the peak, we find significant tokens, significant stable coins of either type, which are subject to the most stringent set of rules. Now, when we look at what aspect of crypto assets fall within regulation, and please bear in mind that this is a briefing today. This is a very high level overview. This is not an analysis of either the law as it might be if it takes the form of the draft that was leaked, or the finished form today, or indeed the finished form when it eventually comes into force. But in broad terms, we can say the key requirements relate to offerings of any kind of crypto asset, including utility tokens. First and foremost, the issuer of the token, if the token is to be offered or traded on a market in the EU, the issuer has to be a legal entity. Typically what we mean by that is a company, although there may be other variations around legal entity. It has to issue a white paper with certain prescribed required information. And although at its base level, that required information doesn't necessarily have to be pre-approved, that white paper and any marketing communications have to be notified to the national competent authority where the legal entity is established. And finally, the regulator has, or each regulator, I should say, will have powers in effect to intervene. So it can require changes to be made to the white paper. It can require an offering to be halted or suspended, or indeed it can publish a notice, a public notice to the effect that a particular issue is not compliant with MiCA. Now, there are a whole set of other provisions, but I think we can say these are the key requirements that are going to affect all crypto asset issuings and offerings. So I'll hand over now to Anna to talk to you a little bit about stablecoin requirements.
Hello, everyone. So in addition to the key requirements for all offerings, issuers of stablecoins will have to comply with additional requirements. First of all, the issuer of a stablecoin will have to be authorized in a member state in the EU, either being established and authorized or registered and authorized. There's some differences between asset reference tokens and e-money tokens. And secondly, their white papers must be pre-approved prior to any offerings taking place. The white paper, as Siân mentioned, and some of you will know, is an information document that contains specific required information, such as key characteristics on the issuer, a detailed description of the crypto assets that are being offered, terms and conditions, and highlighting any risks wherever appropriate. In the case of asset reference tokens, these issuers must be established in the European Union and, again, authorized by a regulator there. And whenever the asset reference tokens being offered are used as a means of payment, they will be subject to provisions in the Payment Services Directive, which is a long-standing piece of legislation in the EU. Issuers of asset reference tokens will have to grant their holders with minimum rights also. E-money tokens have been defined as e-money, which means that they will need to comply with all the rules and requirements under the e-money directive, which is again another long-standing piece of legislation in Europe. It's been around for about 20 years. These tokens can only be issued by either credit institutions or e-money institutions. Credit institutions are essentially banks, and e-money institutions are businesses that have been licensed as an e-money institution under the e-money directive. So entities, a financial services entity that's already authorized under the EMD. These types of tokens must be issued immediately on receipt of the funds and must be redeemable on demand. In both cases at par. So if an e-money token is referencing €1, it will have to be redeemable, at €1. As Siân mentioned in the previous slide, both asset reference tokens and e-money tokens may be deemed as significant. In these cases, they will be subject to a lot more stringent rules. Their supervision will be the responsibility of the European Banking Authority. So they won't be supervised by the regulator that authorizes them, rather by the European Banking Authority. And they will have to comply with more onerous requirements, for example, higher capital requirements, specific liquidity and interoperability requirements, and other. If we could move to the next slide, please, Siân. Crypto asset service providers have been broadly defined as any person whose occupation or business is the provision of crypto asset services to third parties. In essence, anyone that is providing a crypto asset service by way of business. Crypto asset services have also been broadly defined by specific activities, the first of which is custody and administration services. Custody and administration is the safekeeping or controlling of crypto assets or the means of accessing these assets on behalf of someone else. So custodian wallet providers would be captured by this service. Exchanges that facilitate either crypto for fiat or crypto for crypto exchanges will be captured by the second service defined in the regulation. Operating a trading platform is basically the management of a trading platform for crypto assets where third parties can buy and sell interests for crypto assets. The execution of orders, both for crypto assets and more specifically for asset reference tokens, is the concluding of agreements of the buy, sell, or subscription for crypto assets on behalf of someone else. And reception and transmission is the receipt of an instruction by another person to buy, sell, or subscribe for crypto assets, and then the transmission of this order for execution by someone else. The provision of advice has been defined as either personalized or specific advice that is given either at the request of a third party who might be a client or at your own initiative for the acquisition or sale of crypto assets. This definition does not seem to include generalized recommendations. And lastly, payment transactions involving asset reference tokens is defined as a service. And this is basically the transferring of asset reference tokens between accounts on behalf of third parties. Moving on to key requirements. Crypto asset service providers, similar to issuers, must be a legal entity and must be registered in the EU. Normally, this would be a company or a foundation, perhaps, in some countries, or other types of legal entities. Crypto asset service providers must be authorized. They are not allowed to provide any crypto asset services unless they've been authorized as a CASP under this regulation. So, for example, a company in Polish, a Polish company, will need to be authorized by the Polish regulator. In cases where they are making payment transactions with crypto assets, they will also need to be authorized as a payment institution. And they will be subject to other requirements, such as prudential requirements, which are essentially minimum capital requirements and solvency requirements, etc., and organizational requirements. These include that the management and senior management of the CASP has to be fit and proper, which means that they will have the set of skills and experience to carry out their role properly. And other requirements are having in place a business continuity plan, complaint handling processes, and other of the more standard requirements for financial institutions. Just quickly going back to the second key requirement, that crypto asset service providers must be authorized. In the case of banks, e-money institutions, and payment institutions, these entities will not require a separate authorization under this regulation. They will be allowed to carry some or all of the crypto asset services and will need to comply with some operational requirements in this regulation, but won't require a separate authorization. I will hand back to Siân, who will touch on applicability, implications, and next steps.
Thanks very much, Hannah. Folks often want to understand what the legal process is before this applies to them. So let's look very carefully at where we are now on the left-hand side of this timeline. We're expecting MiCA to be published any time now. Last Friday, the Commission alerted folks that this might take place today. That then will follow. This proposal rather, is sent to the European Parliament and to the European Council. The European Council is essentially, for these purposes, made up of the governments of each of the member states, but not the EEA countries. And each of those other institutions will deliberate, debate, investigate, consider, take representations from stakeholders, and then decide on what it is prepared to live with and what it is not prepared to live with, what it wants to see changed, and what can stay intact. These deliberations can take, frankly, any period of time, but certainly we're talking about months and sometimes longer. These deliberations, so far as Parliament are concerned, to a certain extent take place in public. There's likely to be some sort of hearing on this proposal. There will be some aspects of the considerations of those deliberations that will take place in public and some behind closed doors. When each of the other institutions, the Parliament and the Council, are satisfied with their, if you like, their positions, there then follows a period of what are known as trilogues, when the three institutions get into a room behind closed doors and decide on a text, a final text, upon which they can all agree. You see here a faint image of the of smoke rising from the Vatican when a new pope is chosen, and I guess this is a very apt image in the sense that a point will arise at the end of that process of trilogues when the final text will be approved. It will then be translated into the languages of the different, or the official languages of the European Union, and those final texts will be published in the official journal. This is the official publication of the European Union. 20 days after that, MiCA comes into force. And strikingly here, it will be immediately then applicable to e-money tokens. I can imagine a raft of issues that might arise in view of the fact there's no process in place between publication in the official journal, which is effectively the starting point, the starting gun for it becoming law, and 20 days later. But no doubt these will be issues that will be taken up during the period of deliberations. And then follows a period of 18 months. At the end of those 18 months, all the remaining provisions, whether they apply to national competent authorities who will have to operationalize their arrangements in order to be able to process applications, authorize CASPs, for example, deal with white papers, and so on and so forth, and also for everyone in industry. Anyone who is an issuer, anyone who is a CASP, anyone seeking to offer or place or have admitted into a market in the EU will, on that day at the end of 18 months, be subject to the new regulation. Realistically, well, this point from publication of the draft of the proposal through to publication in the official journal, well, it could be 12 to 14 months. To be honest, for a piece of legislation of this size and scope, it would take a major stretch of imagination to think that that could be done in 12 months. 24 months or somewhere between is certainly more likely, but if, for example, in the trilogues, there are difficulties in agreeing texts, it could run on well beyond that. Certainly we saw in a much simpler piece of legislation, which was 5AMLD, the Fifth Anti-Money Laundering Directive, which was probably the last piece of European legislation that directly affected crypto. What was fairly straightforward turned out not to be, not because of the crypto provisions, but matters to do with ultimate beneficial ownership and countries not being able to agree on something that they can all live with. And so that particular piece of legislation took a very long period of time to reach the point where final text was approved. Clearly, what this briefing is designed to do is to start folks thinking about MiCA. It's clear to me it's going to have a profound impact on everything to do with crypto, on pretty much most projects that already exist, on projects being dreamt up, on tokens that are already being traded, and new tokens that are being thought about. It's going to obviously have a major impact on folks like Libra, who've been trying to negotiate with lawmakers, policymakers, and regulators for some considerable time now, trying to find a point, some point that they could live with. And clearly there's a raft of MiCA that's targeted at those type of stable coins. Clearly the intention is that Libra would be considered a significant stable coin. But if you've got something which is deemed a financial instrument, something which is already defined as a financial instrument, say under MiFID, then it's still going to be a financial instrument under MiFID, and you probably don't have to think too much further about MiCA. But if you're offering a crypto asset or providing a crypto asset service in the EU or the EEA, you need to consider MiCA, and you need to start thinking about how it will affect you immediately. Clearly, MiCA sets some pigeonholes, some boxes. There are unlikely to be any grey areas. The grey area of crypto has now been painted very much, well, I was going to say black and white, but in fact, it's probably all pretty black. And you need to think about your activity being undertaken by a legal entity. Essentially, MiCA requires someone, some people, somebody to be accountable. This is what happens in the traditional financial world, and this is what is now expected, seemingly, in the crypto world. With that in mind, the idea of decentralized finance or DeFi and permissionless blockchain is probably not something that's going to work within the EU or the EEA. And there are also wider implications, because this is not just, I think, about the European Union. The European Union is a major trading bloc. It influences an awful lot of global thinking. And there's been a lot of talk for many years now about global coordination, some cooperation between trading blocs to try and come up with a universal approach to crypto. But many nations, as we all know, have waited, bided their time, perhaps sat on the fence. Clearly now they've got a model that they can copy, that they can emulate. And I expect many other nations now to emulate MiCA in whole or in part. So I'm going to finish with a very slightly modified slide that I also showed at the V20 a year ago. And that is that crypto is now part of the global financial system. There is no getting away from it unless you want to block out the EU from your thinking in crypto. Then crypto in the EU is defining what crypto is likely to be across the world. And therefore, it's now very much something that is going to become part of the global financial system. So here are some thoughts. What do you need to think about? Well, right now, you need to start thinking about your strategy. If you're working on a DeFi or permissionless blockchain project, well, it's time for a rethink how you're going to approach it. And you've got to make a decision. Certainly in the medium term, you've got to be thinking about whether or not you want to do what you do in the EEA or outside it. And you've also got to consider whether you're likely, if you're, say, a service provider or if you're an issuer, whether or not you're going to solicit investors or customers within the EEA, because then you're going to be brought into MiCA. You're either completely outside it, cut off the EU, or you're going to have to think about MiCA. And if you're not already in the form of some legal structure, some legal entity, then you're going to have to think about establishing one. And for certain types of tokens, as you've heard through this presentation, and certain types of activities, such as any that fall under being a CASP, you have to think about that legal entity being established in the EU. And so if you're affected by any of what we've talked about today, of course, we're here for you to talk to us. And with that, I'll hand back to Ernest, I think, for a change for me, more or less, bang on time. Thank you.
Thank you, Siân, and thank you, Anna. I hope you all found that useful. Please remember to stay on mute, and if you have any questions, if you've not asked them on the chat, please feel free to raise your hand and we'll try and get to you. We do have a few questions on the chat, and there's a common theme. I think Obi Nwosu, he asked a question around, or a comment rather, but then a couple of others commented on it. Will be interesting to see how they deal with anonymous issuers a la Bitcoin. Jana Pache said she'd second the vote for that question, and Danny Brewster also. So Siân, do you want to take that comment or question?
Well, of course, as we know, in Bitcoin, there isn't actually an issuer. And all Bitcoin has been, in effect, issued, or the machinery by which remaining Bitcoin are going to be issued has already been set in motion. In the case of Bitcoin, of course, future Bitcoin are created through a mining process, and very interestingly, mining activity is exempted from the CASP definitions. I'm sorry, from the issuing definitions, but there is a little catch, a potential catch around CASPs, forgive me. I can't see that there's a scenario where someone would be an issuer of Bitcoin, given the way it currently exists. No one is behind it receiving the funds for newly created Bitcoin. They're created by an external autonomous process, and I don't think that comes into question. However, the trading of Bitcoin anywhere within the EU will clearly fall within the CASP, a range of CASP activities, and probably there are quite a number of them that will actually apply to the trading and other services, intermediary type services around Bitcoin. And anyone who's basically engaged in a crypto asset service within the EU or soliciting into the EU will need to comply with MiCA when it comes into force.
Thank you, Siân. Jana Pache also asked another question. She's asking, will we see some stablecoin issuers starting to seek e-money and payment services authorizations in advance of MiCA being finalized, given these particular requirements are unlikely to change between now and then, and given arguably they already fall within the scope of those regulations?
Whilst the legislation is still being settled, and until it comes into force in probably a couple of years, maybe longer from now, I don't really see any practical way in which that can happen. If, however, it is an e-money token and it falls into that category, then of course the simple solution is for its issuer to be authorized somewhere in the EU as a e-money institution, or potentially even a bank. How about that? Facebook Bank Limited. And certainly that would be one route. And then of course one would be ready to go, because one of the provisions that Anna highlighted is that essentially if you're in certain categories, you're pretty much good to go as soon as things come into force. But I still see some challenges, in certainly my reading of the draft, about that, well, how that will actually work. Because if it is a token, you'll also have to be authorized as an issuer of an e-money token, and who do you go to for that, and how do you do it, and will they have anything in place before the law is finally settled? Because as they say in English vernacular, it ain't over till the fat lady sings. It isn't over until the day it's published in the official journal, and that really is the settled text. So you raise a very good point, and I think it echoes some concerns that I have around transitional arrangements and this very early applicability start for e-money tokens at least, and so therefore for some stablecoin issuers.
Great, thank you, Sean. Xenophon Contouris is asking, how will the EU implement this regulation and limit the use of pseudonymous permissionless ledgers? Can they achieve this? Will they target end users?
Well, within the context of MiCA, no, there's nothing that affects end users. You have to be performing one of the defined activities. So you're either an issuer or not making an offering into the EU. You're perhaps seeking to have a token admitted into an exchange or onto an exchange or onto a trading platform within the EU, into a market somewhere in the EU, or you're undertaking one of the other CASP related activities, crypto asset services. So none of this targets a technology. What it does is it targets activities relating to crypto assets, and so the underlying technology continues unabated. The practical application is that if you want to issue a token into the EU, then you have to be a legal entity. Well, bang goes permissionless ledgers, because by definition, you've then got some sort of governance in place with a board and management and so on and so forth that has some control and will have various obligations in relation to exercising that control in relation to the tokens. So broadly speaking, it doesn't directly address the permissionless world, but it certainly will have a major impact on it. As far as DAOs are concerned, well, there's an interesting one, Xenophon. I mean, by definition, a DAO isn't a legal entity, and so it can't perform any of those things that are going to be regulated by MiCA, and so those activities can't be undertaken within the European Union once it becomes applicable.
Great, thank you, Sean. I think somebody sent me a private question, but I think it should have been addressed to the panel, and it's a Brexit-related question. The question is, following Brexit, do the panel believe that the UK will adopt the EU proposals?
Well, Ernest, you have done considerable work on Brexit in the past in relation to the arrangements that Gibraltar had to make, and you're currently engaged on similar work at the moment in relation to the end of the transition period. So I think you're ideally qualified to answer this question if you can. Yes.
So as far as I'm aware, there's no agreed position from the UK as to whether or not they will be adopting all of these kind of EU proposals. And I think it's one of those things that the UK will be considering on a case-by-case basis. Of course, the UK already have a regime in place from an AML point of view, so they may follow the EU to some extent and extend the current regime so that it covers other type of activities and it aligns as much as possible with the EU. But I'm afraid to say that I don't think there's a clear-cut answer to that question yet. It's something that we just have to wait and see how things turn out.
I'd probably just add one comment to that, which is that it all depends what kind of Brexit actually emerges. I know Brexit's a done deal. The UK left the EU at the beginning of this year and is now engaged in a transitional no man's land where, in effect, current laws, EU laws, still apply in the UK. So they still apply also in Gibraltar. But come the end of the transition period, which is set for the end of this year, and which Prime Minister Johnson says will not shift under any circumstances, then frankly, it's anybody's guess what that might look like. Although at this late stage, we're almost into October. You know, if you were asking me to put a bet on it, I would say that there will be some sort of agreement at the end of this year. It won't have much of substance in it, probably. And it almost certainly, I think, won't cover financial services. So that raises then a very interesting question for the UK. Does it seek to find alignment across the board in financial services so that it can try and find some way of creating bilateral arrangements in time with the EU? This is pretty much what happens with Switzerland. Switzerland has, I think, over 200 bilateral agreements with the EU, covering a vast range of different things. Some are covered by those arrangements, some things are not. So it's not a member state, it's not a member of the EEA, but it operates on an equivalent basis on many levels. So if the UK seeks to try and find that alignment with a view to such a future agreement, then I imagine it's going to have something very much like MiCA in parallel in the UK. If, however, it sees no hope in doing that and seeks therefore to be competitive against the EU, however laughable that may or may not sound to you, then it might well choose the opposite path and find something that's quite different. But at a number of levels, I think we are going to see alignment universally across the world. If you were asking me, what do I see for 5 to 10 years from now globally, I would say most nations will have something that looks a lot like MiCA. If it's not MiCA, it'll be something that in some part or in totality will be a MiCA-like.
Thank you, Sean. Pierre Ostenkamp is asking, since significant tokens are subject to more stringent requirements, what would the implications of MiCA be for a project like Libra?
Ooh. Well, I should think they consider that much of MiCA is targeted at them and going to make life very difficult for them. On the one hand, they've craved for recognition by policymakers and legislators around the world, and particularly in major trading nations. Clearly, this is not very helpful for them. So I dare say they will be smarting from the direction that MiCA is going in. But that doesn't mean abandon all hope at the Libra Association, but it's certainly a major constraint.
Yeah, we'll take one more question and then I'll close. And then, as I said before, we'll stay on. We've got a number of other questions I can see in the chat. We'll take the question from Emma Heard, which we've more or less touched upon already, but I think it asks something from a different perspective as well. So she's asking, how will this affect companies who have already deployed DAOs and DEXs prior to the regulation being enforced?
Yeah, and it's a similar scenario to the point that was made earlier about Bitcoin and some other conversations I see here in the chat about putting Bitcoin back in the bag. You know, this is we can't turn history back. I don't think that the EU sees that as an objective. What will happen is that if you want to perform any of the activities relating, any of those activities that are caught by MiCA, either in terms of issuing, in terms of admitting a token onto a trading onto a market within the EU, or undertaking any CASP-related activities relating to any of these things, then you are going to have to comply. You, the legal entity, as you will have to be, are going to have to comply. And if you aren't a legal entity, then those things cannot be done within the EU. That doesn't mean that Bitcoin is valueless within the EU, or that existing DAOs and similar arrangements can't operate, but their activities, or the activities of people engaged with them, will be severely hampered. There will, of course, be a big question around whether or not individuals, or which individuals, might be considered to be breaking the law. Let's put it that way, when the law comes into force. But that's a long way down along the line, and I dare say we will see guidance and so forth from some of the institutions before that happens.
Perfect. Thank you, Siân. I'm very conscious about time, so let me take this opportunity to thank you, Siân, and thank you, Anna. I hope everybody found that useful. I'd like to thank again INATBA for providing the facilities and logistics to make this possible. And most importantly, I'd like to thank all of you for taking the time to attend the webinar. As I mentioned before, we will be issuing a detailed paper over the next week or so on MiCA. If you'd like to get a pre-release of this document, or any other future publications or invites to webinars that we may issue, please feel free to subscribe on via the URL, which is on the slide. Let me just check. Have we?
It is.
Yes, it is there. Sorry. As I said before, we'll be closing the meeting now. Thank you, everyone, again. But if anyone wants to stay, I can see that there are a number of questions and comments that people have raised in the chat. We'll be keeping this open, and we'll be happy to have a networking session or answer those questions or any discussion. Thank you. I can see that there are a lot of questions and comments on the chat.
Hi, Nina. Sorry to interrupt you.
No problem.
I was going to ask, well, first of all, thank you. That was amazing. But are there any provisions around equivalence in the leaked draft?
Equivalence in respect of, in what sense? Sorry, do you want to elaborate?
Yeah, sure. So equivalence with respect to MiFID style equivalence determinations. So are there any powers granted to the Commission to make an equivalence determination in the draft?
I haven't come across anything in relation to equivalence. So no, I don't think there's anything in the current draft.
Thank you.
There will be passporting within Europe, but that's something entirely different. So as an EU-wide piece of financial services regulation, if you're authorized in one member state, you'll be able to passport from your home state to other EU member states, but nothing that I've seen either about equivalence. No.
I was just to add to that, there is equivalence will be considered. So as part of the deliberations and everything else, there is a section in the proposed draft where it says that it will consider whether an equivalence regime will be established, but there's nothing more than that.
And that, I think, is in the explanatory note rather than in the text. Is that right? Rather than the legislation.
The transitional and final provision.
Okay.
One of the titles.
Okay, so there is something that will be in the legislation to give force to that. Oh well, there we go, Jana. It's a very lengthy document, and it ain't done yet. So forgive. There will be a lot of detail that will emerge over these coming weeks and months. So it turns out there may be.
Okay, Samantha Kuhn, I can see your hand up. Please introduce yourself. And
hi, Samantha from Malta. Thank you for today's very informative session. I just wanted to ask, I've been over the MiCA, and I noticed that they're only catering for payment services with respect to asset reference tokens. And crypto assets haven't been accounted for here. What are your views on this?
Anna, do you want to take that one?
Yes, as part of crypto asset activities, I know that the services have been defined both for execution of orders with crypto assets, and then there is another definition for execution of orders with asset reference tokens only. I'm not entirely sure whether crypto asset service providers providing the service of payment transactions with crypto assets only will be required to comply with the Payment Services Directive. I don't know, Siân, if you have seen whether only asset reference tokens will be included, but
my recollection, I think, is it's only asset reference tokens, but you've raised an interesting question. I'm going to delve into that one.
Mm-hmm.
And we'll get back to you on that if
all right. Yeah, thank you.
Interesting, very interesting question, actually.
That's another thing that I wanted to mention. I know we've got a lot of other questions on the chat that we haven't answered. I'm happy to go through them. I'm not sure if everyone is still in the call, but otherwise we will be following up by email and trying to reach out to you to answer your questions or have a discussion on the issues that have been raised.
Does anybody else have a particular question they'd like to raise now or discuss?
I can see.
Just raise your hand. Nina.
Nina.
Thank you. Thanks. Thank you, Siân and team, for this presentation. Very helpful, especially if one has not had time to really dig deeper into this lengthy draft. I would like to return actually to the Bitcoin discussion and the other discussions being raised regarding DeFi. I am where we agree, Siân, when we talk bilaterally, that in most of the cases, the claim of being truly decentralized is probably not correct or 100% true, but assuming it is compared to what you stated about Bitcoin, then that would not be touched upon by MiCA, right? And then the question is, what defines decentralization and what, what phase do we need to reach?
I think it's the other way around, Nina, actually. I think it's, if you want to do any of these defined activities or have them done within the European Union, it will have to be not decentralized. I think that's the implication. It isn't that it allows for something that is other than centralized. It only sets centralized rules, and the requirements are that you have to be a legal entity. So if you aren't a legal entity, you can't perform those things.
But as you just said, Bitcoin, you can find an issuer, but Bitcoins are issued, right? They are issued without an issuer. And that's basically the trick, right?
Yeah. If they're not being offered, so nobody's paying for Bitcoin. You'd have to pay to exchange a Bitcoin. And then it depends whether that activity of exchanging something of value for Bitcoin is deemed a crypto asset service if it's undertaken in the EU. If it is, then it falls within MiCA. If it isn't,
but the question
transaction,
is, if you set up, but in case you set up a piece of software, right, which actually takes funds, Ether, Bitcoin, what else, in exchange for something else, then nevertheless, you have no operator for that service. Right?
I mean, that's going to be really interesting. My expectation is that regulators will define that if you're instrumental in some way or benefiting in some way, or I mean, this is something I alluded to in one of the slides, that it's not yet defined and is not yet clear what level of personal activity or involvement might have regulators deeming you to be the one doing the offering or performing the service if it's a swap, say. I think that will emerge in time, and the demarcation, but my expectation is that they will define a whole range of people or things that people do that might bring them in certain circumstances into the frame, so to speak. And if they don't then comply, they'll be breaking the law.
That's clear. And it's also crystal clear to me that if somebody personally participates financially in any of these things, then that's kind of centralized again, right? So that doesn't count. But if there is a mechanism set up providing for these services on an automated basis and, with no backdoor or alike, it really gets interesting what will happen then. Are you aware of any discussion surrounding regulating software coders in this respect?
I've been involved in conversations around that for about 1.5 years now. It was exactly the same set of discussions went on within FATF and continues today. And I expect very similar conversations to be going on in some of the supervisory authorities like the EBA and ESMA and so on. I don't know of any specific conversations. They're certainly not being shared publicly, but I'm pretty certain that they are. And I'm pretty certain there's a lot of thought going into where that dividing line comes. But if you're asking me, will coders end up being sucked in and held accountable? I think it is not beyond the realms of possibility that certain activities relating to deploying code, certain activities relating to committing code to and so on and so forth. I think some of those activities will, depending on the facts, may well end up being sucked in, and I suspect that these matters will, in time, probably end up in the courts, and there will be arguments and decisions made about whether or not an individual, were making an offering whilst you weren't doing so in a compliant way. That makes people nervous, of course, and you could argue that it doesn't therefore achieve legal clarity in its totality. But then, if everything was clearly defined in law, there would be a lot of out-of-work judges.
Yeah, it just surprised me that they did not touch at all on this very obvious subject, right? I remember that Switzerland, they included an exemption for decentralized, I believe, exchange services in their regulation last year, right? So they didn't close the eyes and but try to more proactively address this topic.
Yeah, I mean, there is a very clearly stated aim at the beginning of the draft around why this is being proposed, and one of those aims is around supporting innovation and so on. I think everybody will determine whether or not the balance has been appropriately struck and whether it's proportionate given the potential of this new technology. I would also say that there are fans of crypto in its broadest sense, in terms of the benefits that can be brought to EU citizens in particular. There are fans of crypto within the European Parliament, and they're a growing band, so they may well seek to amend this proposed regulation to provide more clarity. It's an interesting one. I've just seen your comment in the chat about ultimately that they could make coding a regulated profession. Of course, that's possible, but unlikely. But the performing of various functions within coding or within the whole tech stack could well be defined as an activity that's deemed to be facilitating an offering, for example. I can imagine concepts like that emerging, but not this week, not this year, and probably not next. But in time, I think these things will emerge. I'm hopeful that the Parliament may actually resist, and I would, for those who are still on the call, and a lot of you are, you know, you all live in a country, and you all have governments, and you all have the possibility to make your views known, and in doing so, you can potentially influence or temper some of these provisions. And remember, the governments together are forming the council have to agree a text, something that they are happy with. Similarly, 750, well, now less, sorry, after the Brexit, it's less, but what is it, 600 and some MEPs represent the people of Europe in the Parliament. And they too, and there are those who are very knowledgeable on this subject, and there are those who have made it their business to understand the potential benefits to society and EU citizens and to civil society in particular. And so they have a cause. And with that in mind, I would suggest that, you know, vested interests should start to think about how they marshal their efforts with the Parliament, with members of Parliament, and with their governments.
Yeah, and that should probably give rise to the invitation, you know, together in our working groups at INATBA to contribute to this whole process coming up now, and making sure that everyone's voice is heard.
Indeed. Now, I noticed there's also a hand up from Camille. So, Nina, let me hand the baton over.
I was going to turn to Camille now, who's been very patiently waiting with a hand up.
No problem. Thank you. Hi, Camille, working with MFSA in Malta. My question is about the impact of MiCA on something like travel rule. We've seen jurisdiction taking different approach when they need to implement the travel rule. Is a unified approach proposed with MiCA, or is this being treated?
No, it's an EU regulation, which means it's directly applicable across EU member states and also in this particular case EEA countries, and so there is no requirement for transposition. And I believe the reason that the Commission proposed a regulation rather than a directive, which would have had to be transposed and therefore could have slight national variations, I think the reason for that was to avoid arbitrage and difficulties in implementing. So it will be once it comes into force, and the two applicability points that I highlighted on the timeline, once they occur, then it will be applicable across the EEA.
Sorry if I was misunderstood. My question was about FATF travel rule, which is being extended and that jurisdiction needs to comply with by June 2021.
Okay, well, the travel rule, I know it's a little off topic, but I will certainly answer it because I have some very personal knowledge of it, having sat on the development group, policy development group, which brought it in when I was still a regulator. The travel rule, in effect, became a requirement on FATF members and members of FATF style regional bodies, so effectively all countries of the world, pretty much. Already in October 2018, with the change to recommendation 15. This was the change that one sentence change which brought VA virtual assets and virtual asset service providers into scope. Of course, it wasn't clear straight away what that meant for countries, and that only became clear when the interpretive note and the guidance, the risk-based approach, the risk-based guidance, was published in the summer of 19. Sorry, so a little over a year ago. Essentially, from that point, there was an expectation by FATF that all countries would implement all the provisions immediately. Of course, at a practical level, it doesn't work like that. But any countries that were subject to FATF mutual evaluations in short order of time certainly acted very quickly to implement those FATF provisions, and they included the travel rule. Now, there was a 12-month review carried out by FATF, which the report for which was published a few months ago. I think it was back in July. That reported on a number of things, including the implementation by countries of the requirements on them, so their obligations. And I think there were around 30-something countries that reported at that stage that they'd already done stuff. Some were had already operationalized, some had not yet operationalized, and some had not yet done anything about the travel rule in particular. And those that had, I think pretty much all of them had said that they were not enforcing it because the mechanism by which that could be done, the technical capabilities, the technical solutions were still under development. And so FATF decided to have a second 12-month review in the summer of next year, and hopes to see a much more significant implementation by countries, and also hopes that the travel rule solutions that have been worked on over the last year or so, and some of which are now sort of coming to market. Some are fairly complete, some still have pieces missing, but that there will be sufficient technical solutions operational by next year to be able to say that VASPs are able to comply with the travel rule and are doing so where it is a national requirement for them to do that. So I'm sorry, that was a rather long-winded answer, specifically off topic, but on a related one. What I would say is that the Commission has sought to very closely align its definition of crypto assets and crypto asset service providers with the FATF term virtual assets and to a certain extent to elements of the definition of virtual asset service providers. So there's a much closer correlation between the two. I hope that answered your question.
Yes, thank you. And if I could add on that, I know, for example, that Switzerland is proposing an outright ban to VASP that don't comply with the travel rule. How is that taken in account with MiCA? Because obviously we need a unified approach, and all European countries needs to follow the same approach regarding the travel rules. So is that taken in account by MiCA, or is that not in the cards?
No, MiCA has no relationship to the travel rule and anti-money laundering legislation. It's also worth mentioning that Switzerland is not an EEA member, so it is outside of the European Union and the EEA. It does have a lot of bilateral agreements, as I mentioned earlier today, with the EU, so arrangements which provide it with very similar or identical provisions across, I think, around 200 different sectors. But since MiCA doesn't exist yet on the statute book, I don't know of anything that the Swiss have in mind to bring in alignment, although it would make perfect sense for them to do so. But in relation to the FATF requirements and the travel rule, they really aren't touched on in MiCA.
All right. Thank you very much for taking the time.
Thank you, Camille. We've got a couple of other hands raised. Pierre, the floor is yours. Go for it.
Well, thank you, first of all, Siân, Ernest, Anna, and everyone who's here. This is a really interesting webinar. I would like to ask if coders are brought within the scope of regulation. Could we see an industry where new disseminated and deployed by coders who then try to avoid being identified in order to avoid regulation? Or does this spell the end of DeFi and decentralized projects altogether?
Oh, that's a lot of hypothetical, built on hypothetical, built on hypothetical. It's a difficult one to answer. So I'm giving a personal opinion. This doesn't really, in that sense, relate to directly to what's in the draft of MiCA. But I mean, you will always find people who want to sit outside and sit outside on the margins. The history of the cypherpunk movement and the early days and to some extent still today of certain elements of crypto still seeks to sit in the shadows and to a certain extent there is some success. But I mean, if you are found to fall within a definition or you come into scope and you break the law and try to hide from that, that doesn't prevent you from being exposed at some point in time, and somehow sanctions, criminal sanctions being taken. I mean, that is always a possibility.
Thank you.
I don't recommend it.
Okay, so we've got Jordi.
Yeah, thank you so much, and thank you to the entire team. Incredibly useful. Also a little bit depressing. So for projects like, say, Uniswap or Balancer or any of these DeFi projects who do not want to expose themselves to criminal charges, is turning their projects into permissioned projects, is that the key remedy? Or these guys are just unable to operate at all?
No, I think folks will come up with ingenious solutions. I think, dare I say, people like us at XReg will work, you know, because of our knowledge of the technology and our knowledge of regulation, will find solutions that will, you know, particularly certain types of governance solutions that might still have some accountable body and some minimum level of governance, whilst still keeping some elements of the benefits of DeFi, but it won't be DeFi as we know it today, I think. Mm-hmm. Or you don't do it in Europe. I mean, that in the EU. That's, of course, the other solution. Just stay outside Europe, it's not a problem.
Right. And just for clarity, if Uniswap wanted to operate in Europe, would that mean that they would have to permission their users, like whitelist all users? Is that like the number one change they would have to make?
I mean, I think it might confuse two different points here, because the issue of whitelisting implies issues around knowing, you know, knowing one's investor, knowing one's customer, knowing one's token holder, or however you want to describe that. And I think in that circumstance, that really is a matter that falls into the scope of anti-money laundering legislation rather than into MiCA. So it would be looked at, I think, as a different issue. But in order to perform all your obligations, for example, to make sure that, you know, if you say Uniswap is performing kind of activities that it does today, then, you know, there'd be a very interesting question about whether they fall within the definition of a CASP. And then you've got to say, well, who is it that's falling in there, or who is performing those activities? And we come back to the points that then we talked about earlier on in the question and answers. Mm-hmm. I would definitely say, you asked the question, is this it for DeFi? I think it is. It poses very significant existential questions for DeFi as we know it.
And so, like, and I think I already asked, but like, how can DeFi, like, how would DeFi need to evolve to be compliant? Like, what's the remedy, if any? Or are you saying that really is it? It's really dark black.
No, I mean, the legislation is just being put out there. Our team of 7 have been looking at it since it was leaked a couple of weeks ago, and pretty much all of us are looking at it, poring over it, thinking about the issues. And I think over the coming weeks and months, it will become apparent precisely the direction of travel, where there may be scope to do things and come up with some novel ideas, but I couldn't tell you today what they are. Mm-hmm. The best minds will have solved problems in crypto, and I'd like to think the best minds will solve problems in the regulation of crypto too.
Thank you.
Thank you, Jordi. Obi, I saw your hand up before. Do you still want to ask a question? Are you still there?
Yes, and no, I'm still there. Hey guys, thank you very much for the talk. Well, there's 2 questions. One was a meta one, which I think you're going to follow up on anyway, which is there's a lot of interesting questions in the chat, and it would be great to still go through those and hear the answers. And just one of the questions I asked, which was, you mentioned a clarification in the leaked document around mined coins. Does the same thing happen relates to stake farmed coins or airdropped coins? Are there exclusions for those, or they're not clarified? And similar.
There is reference, although not using the term airdropped, but there is a reference to the issuing of tokens through what amounts to an airdrop being not considered an offering or exempted from the definition of an offering, and similar. There's specific reference to mining or mined tokens. There is no reference to anything else, and I'm quite expecting those kind of questions will be teased out through the deliberations period by industry members who will be making representations to interested parliamentarians, who will definitely, I think, want to run with that and see what would be the equivalent and where the dividing lines might be. So I would say watch this space, but you need to engage with your MEPs, with your industry bodies, and with your governments. Sadly, Obi, I know you're based in the UK, and so I'm afraid Mr. Johnson's government has no say in this. But yes, in the EU, if you have a say, or if you are a member of an industry body such as INATPA, we're members also of INATPA, then those bodies will, I'm sure, be making strong representations and lobbying on exactly these kind of points. I would love to have definitive answers on everything. And of course, what we've got here is a leaked draft of a proposed piece of legislation that's slated to come out today, and that will change. So it will probably be slightly different from the leaked version. It's going to evolve as the deliberations take place, and it might have quite a few changes in it, but not fundamentally different, I don't suppose, by the time there's an agreed text. Meanwhile, it's impossible. We can't say any of this. Well, we don't give legal advice, but we can't say whether any of this is how it will be interpreted yet. It's far too early. We're trying to give everyone a high-level indication of what is happening, what its implications might be, how it might affect different stakeholders, and then hopefully folks can start to engage and think about these things. There isn't a lot of time, you know. Once it's published, it's at Parliament, and Parliament has to timetable it. So one needs to start actively thinking on these points very quickly.
Thanks, guys.
Thank you, Obi. There's, I'm conscious about time. I think we've got some more time, right? So we can go through some of the questions in the chat.
Yeah, shall we take, there's one more hand up. Ernest, shall we take that one? And then,
I'm sorry, I missed that one. Danny. Yes, Danny Brewster, go for it.
Hi, brilliant presentation, and I've calmed myself down now from the thought of trying to regulate developers. But back to the contents of the proposed legislation, surrounding advice, do you feel that the legislation will fall under existing frameworks for providing advice by authorized persons, and would say telling somebody buy a Bitcoin because of this, or you should buy a Bitcoin for this reason, that reason, or the price is going to go up, or is that going to fall under that scope, or is just educating somebody going to be considered as providing advice?
I think, Anna, this is probably one for you, no?
Yes, well, the definition of this service has includes personalized and specific advice. So it doesn't appear to capture generalized recommendations. But then the way that personalized and specific is then further defined will be the answer. In other traditional financial services, advice, for example, that journalists provide or anything that is broadcasted, it needs to comply with certain rules. And in this case, it appears as if generalized advice won't be covered. But again, we will have to wait to see the finalized version of the regulation. Did you want to add anything to that, Sean?
No, I think you've covered that very well, and as it seems to be defined, if I advise you, Danny, to buy sushi because it's going to go to the moon tomorrow, then that would probably be personalized advice, even though it's on my own initiative. But if I broadcast on this presentation, this seminar, that Bitcoin, I think Bitcoin's going up tomorrow, I think everybody should buy Bitcoin, that's probably generalized advice, and appears not to be in the sights of MiCA at this stage anyway.
Great, thank you very much.
Thank you. We've got another hand up. I can't see your name, sorry. So DM.
Hi guys. No, it's Sean. It's there, Markova. I'm not trying to be on purposefully hiding my name. I just didn't realize which part of the sign up process comes up on this. So yeah, I'm not trying to be secretive or anything. No, but I'm just wondering. So as a background, I work in a public affairs capacity in Brussels, and we know each other with Sean for a while. But so I'm kind of going back to your point about how problematic it could be about the industry to have to register an entity in order to do a token offering, which I understand it's kind of against the DNA of the industry in the first place. But if you think about the DNA of just rules in the EU, if the Commission wants to levy requirements onto someone to issue tokens, utility tokens, in a particular way with a particular set of requirements and white papers and all these other provisions in MiCA, but they can't levy them onto a legal entity, what is a possibility here?
Well, one of the requirements is to be a legal entity, and in some cases to be authorized by a competent authority within the state. So, you know, if you then perform that activity and you're none of those things, you're not complying with the law, and you're in breach of the law, and there are proposed sanctions.
Yeah, I guess my question though is, if they're trying to do the right thing and not kind of wipe off part of the industry, but at the same same time, they do need to levy a requirement onto someone. What is, like, how do you fit that, you know, square in a round hole?
Well, you know, policy, you've been involved in this, in policy making for some time. And policy making is about finding balance, usually between competing interests and competing objectives. There were 4 stated aims, legal clarity being at the top of the list, supporting innovation being in that list. And there's the suggestion that in all of this, there's a balance to be struck. I think the world will determine whether or not in this draft, or rather in this proposal, that balance has been proportionately met. I can imagine lots of my friends in the crypto space would almost certainly say not, and I sympathise with their view. I think it will be particularly challenging. It's designed to make, well, I say it's designed, I mean that implies a purpose, but the consequence of this is it makes crypto assets, or at least the issuing and offering of crypto assets and certain crypto asset services, like their equivalents in the traditional world, regardless. And that means including being an entity and being authorized in some cases. And that's just a reality of the traditional financial services world. You can't be an anonymous person offering banking services. Same thing is I think the outcome of MiCA. Then you will ask the policy question: well, has that balance been well struck? You know, does it meet those objectives in the right proportions? And of course, that's one of the reasons why the Commission proposes legislation, and the Parliament, representatives of the people of Europe, will review and amend. And clearly, I think they're going to be quite engaged on this one, because there are issues of that balance that some will have very strong views about. That balance may not have been properly struck, that the scales are tipped one way. I've certainly identified, and my colleagues at XReg also, other points where it seems not to be a level playing field. And I'm sure that, you know, you say, well, okay, level playing field is one thing, but then, you know, can you both support innovation and meet all of these, or can you support innovation adequately with this kind of legal clarity? Could something more imaginative be done around in some areas? And I suspect the answer would probably be yes. You know, all of us have been involved in creating a new way of regulating DLTs. So DLT providers are pretty close match to this term CASP, and in Gibraltar, and we did that. So that law was passed in 2017, and it was a completely novel way, a new approach to do it. It is possible, but of course there has to be the imagination, there has to be the will, and of course Europe is a much bigger place, and there are many more vested interests.
So I think that's it. We're done. Thank you, everyone, again. I hope you found that useful, and feel free to reach out to Anna, whose email is there still on the slide, or you can subscribe on that URL, via that URL, to obtain that information that we will be publishing over the course of the next few months. As I said before, this is the first of hopefully quite a few webinars that we will be delivering on this subject. It's clear that there are a lot of interesting discussions to be had around a lot of the different issues and principles that are being brought about by this new EU regulation. So thank you all once again.
Thank you.
Bye-bye, everyone.